Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I'm the principal attorney at the firm. Today's review, we're going to be looking at a privacy notice related to Calendly. So this particular notice was updated October 17, 2025, and this first sentence talks about the scope. So we can see the notice describes how Calendly collects, uses, and discloses your personal data in the course of their business. Okay, and they've also provided definitions. So let's look at applicability. I've talked a lot on this channel about scope. So essentially, this notice only applies to personal data for which Calendly acts as a controller, such as when you visit the website or create an account for our services. So this is a really important sentence to have in the notice, because what it essentially does is it lets the applicable consumers know whether this notice applies to them, right? So this notice is where they act as a controller, such as when you visit the website or create an account. This doesn't apply when Calendly is in its capacity as a data processor. So they're very different in that the controller determines the means and purpose of processing, and the processor acts on the instructions of another entity. So if Calendly ever is in its capacity as a processor, you're not going to see its privacy practices here because the scope has been outlined in this sentence. That's what this means. Now, I will say something that I think is interesting, the use of the word controller. Let me see if there's a definition above. I've talked a lot on this channel about tone and having the right tone for the privacy documentation that a business has. So this is what we consider a external privacy notice. The audience here are people that are signing up for the services of this business. So what businesses need to consider is, are the customers in scope of this notice going to understand what I'm talking about? Are they going to understand privacy terminology like controller? Are they going to understand privacy terminology like processor? So it's really important to have definitions if you're going to use privacy related language and to understand who it is that is your audience. Now, if this was a document that was being distributed amongst privacy attorneys, I would say that it's okay to use these wordings because we understand what this means. Same with this one. The definition of service provider is very unique in the US context, and a privacy counsel is going to be able to distinguish and understand what is trying to be conveyed, as opposed to someone who's signing up and creating an account. Now, even though consumers are becoming more savvy about what personal data is, what privacy is, etc., when they're reading a notice and trying to understand what is happening with their data when they create an account, it's really important to put language that they'll be able to understand. And if you're going to use privacy specific language, put a definition and make sure that's consistent throughout. Information we collect and process, information you provide directly to us when you visit our website, account creation, billing information, marketing information. Now, what I want to say about this information we collect and process is everything within the notice ties back to scope. Everything. Every single provision, how we use your information, with whom we share your information, children and educational service providers, your rights, etc. The reason why this sentence is so important for every privacy notice is it's really important to outline who you're addressing and why every single paragraph within your notice applies to how you use personal data. I'll give you an example. If this privacy notice was explicit to how Calendly processes personal data related to employees, the information that they collect and process is going to be very different to what's displayed here. Same with how we use the information. If you have an employee in your business, you're going to use that information to maintain your obligations from a regulatory standpoint related to employment laws. How you use your information is going to be reconciled with the applicability where your processing is for employee matters. So when a privacy counsel drafts this, we always look at the scope first, because if there's anything that's inconsistent with the scope throughout the notice, then we're going to query it. And this is why I think it's valuable to have a privacy counsel draft this, because if you purchase a boilerplate template for privacy, you may not be capturing everything that needs to be captured related to how your business uses personal data. And I've talked about this before. It's impossible to do business in any capacity in 2026 without personal data. And we see this because this information that's collected about you automatically, right? You see log and device data. There are certain identifiers that might not necessarily on its face look like personal data, but an IP address does constitute personal data because it identifies an individual. If you're not clear on what might constitute personal data, you could put your business in jeopardy of being non-compliant, deceptive, or misleading, which is in contradiction to the FTC Act Section 5. So many businesses think that the privacy laws only apply to large organizations, but there's different thresholds, particularly throughout the United States, that could bring a business under compliance obligations for specific state privacy laws. And as it currently stands in 2026, we have 23 states that have state-specific privacy legislation. So if you're a business and you operate even on a national basis within the United States, let's not even talk about global. If you're operating in the United States on a national basis, meaning you provide products or solutions that are being sold to consumers, individuals within the United States, you need to not only take a look at, do I meet the threshold in those 23 geographies, but you also need to look at industry privacy legislation and whether you meet the thresholds. And then you also need to look at federal privacy legislation and do you meet the thresholds. So you as a business owner, you're not looking at privacy from, oh, do the big tech giants have to adhere? You have adherence obligations, even on the federal level. If we look at the language in the FTC Act Section 5, it talks about using unfair and deceptive practices. Those apply to privacy too. If you're missing out specific identifiers that you collect on your public-facing website, you're basically telling me as a consumer, this is what I do, and it's not actually what your business is doing internally, you put yourself in jeopardy of non-compliance. And that non-compliance has a lot of repercussions. We've seen that in the news. If you listen to my podcasts, you'll have heard of examples that I've given about how businesses have been caught with privacy practices that were non-compliant and they were hit with lots of different fines. In addition to those fines, you lose your customers' trust. So essentially, I guess the question is, what is your business worth to you? Is it within your interest to be proactive about privacy rather than find yourself in a situation where a regulator in one state says that you meet the thresholds that you didn't know about and you're issued a fine? So that's really what's at stake. Let's keep going. Let's talk a bit about cookies. I have several audits and reviews on my channel related to cookie notices and cookie process flow. If you're interested in what a cookie is, I have several different videos on what a cookie is. But again, I wanted to talk about this because a cookie, when you look at it, traditionally doesn't look like a personal data identifier like an email address. What's unique about the data protection laws is if a specific identifier can be associated with an individual, it's personal data, and cookie falls within that spectrum, which is why you'll see things like a privacy notice and a cookie notice, because they're separate in that cookies have a specific flow depending on geography. The United States has very explicit discussions about how cookies can be distributed when consumers are interacting with a site. And in other geographies like the European Union or the EEA, there is a specific manner in which cookies can be collected that have to be adhered to by global organizations. So I really hope you enjoyed this simple review. If you have any comments about what I have stated, or if you're interested in working with a privacy lawyer, take a look at my description below and I'll see you in another review.